Chapter 8, Tort Law in Cyberspace. So we'll be talking about wrongdoings, but now in a setting of private law, civil law, and not criminal law as we discussed in Chapter 7. So what are the objectives of this Chapter 8? So we'll discuss the general principles of tort law, and I'll have to differentiate tort from crime. And then we'll look at several torts, types of tort that are related to online conduct. We'll be focusing a bit on the types of invasion of privacy torts that are some here. And then one of them is the right of publicity, so we'll also discuss this. And some other torts, which are the intentional infliction of emotional distress, also negligent infliction, both in the online environment, and we'll also discuss some economic torts. And we'll finish this chapter by looking at some not only remedies available for the victims, but also what the defenses for those torts are. So the defendants, what defenses are available to them. So let's start by looking at tort law. So first of all, similarly to contract law, tort law is mostly derived from common law cases, precedents, even though there are some statutes for torts, but the main concepts and most types of torts, they derive from past decisions or case law or precedents, as we already know. And what is a tort? Well, a tort is a civil wrong, is a private wrong. It is a wrongdoing. It is when the defendant breaches their duty. And what duty is this? It is the duty that the law imposes on everyone in a way to stand in a particular way in relation to another. So meaning I cannot cause any injury or any losses to another. This is tort law. So tort law is related mostly to provide compensation, not only, but mainly compensation opportunities for victims of civil wrongdoings. A very simple and best example here would be a car accident. So in a car accident, the victim will probably suffer losses, car related to the car, eventually some injuries. And what is the field of law that provides remedies to the victim in a car accident? It is tort law, because the car accident is regarded as a civil wrongdoing. So the defendant, in this case, the wrongdoer, acted in a wrong way. Could be intentionally or could be in a careless way, negligent way, but still the wrongdoer caused losses or injuries to the victim. So tort law will provide the victim with remedies to seek compensation, mostly monetary compensation for their hospital costs, medical costs, but also to fix the car and to have the car back as it was before the accident. So that's what tort law is. And you may think that tort law is the same as a tort, not tort law, but a tort, a civil wrongdoing, is the same as a crime. And actually, it is not. Some types of torts, they are also crimes. So, for example, if someone steals something from me, it is a crime. But on a private side, on a civil side, I also suffered loss because I don't have my smartphone anymore. So the theft of a smartphone is both a crime and also a tort. Um, but see, the difference is that the crime is actually a social wrongdoing. It is regarded as a social wrongdoing. And in a criminal activity, I am not the one pursuing the accused. It is the state, it is the country, it is the prosecutor that will, the police that will lay charges on the accused, and then after the criminal proceedings, the accused, if found guilty, may have some jail time or some probation, etc. So a criminal conduct is different from a tort. Tort is the civil side, is the private side. The victim is seeking um, to get remedies, to get compensation, to get any other orders to deal with their losses or injuries. Whereas a crime is a conduct that is prohibited in a criminal code, and the accused will suffer the punishment that is prescribed in the criminal code. So those are different things. They have different proceedings, and this difference has to be very clear to you. Again, the theft example I've given you is both a crime and a tort, but still the tort will be dealt in a way, and the crime will be dealt with in a different way, as I explained. Okay, so we'll be focusing in this chapter on torts, types of torts. So we'll be dealing with wrongdoings, civil wrongdoings that has potentially caused the victim losses, eventually injuries, and then the victim will seek one of the remedies that are available to them. Mostly, in most cases, it is monetary compensation. A tortfeasor is known as the person who commits a tort. This person can also be called as a wrongdoer. Technically, it is more used tortfeasor, so you should just know this name. And tort law, as I said, it is mostly derived from common law, based on cases, previous cases, etc. And in the US, it is governed by state law. So each state will have their precedents, their cases, which will detail the rights, the duties for, or general principles for tort law. So moving on, we have some categories of torts, and it is important for us to understand. So first of all, we have the intentional torts. And by the way, the majority of torts related to the internet, they are intentional torts. And what are the intentional torts? These are the ones in which the wrongdoing and the results were intended by the wrongdoer, by the tortfeasor. So the tortfeasor actually intended to act the way they did. They intended to actually cause the results they caused. So those are intentional torts. We also have the negligent torts, so torts by negligence, and these are the unintentional or careless torts, careless wrongdoing. So again, my car accident, in most cases, if not all, a car accident does not happen intentionally. It happens because one of the drivers, or eventually both, but usually one of the drivers, was careless, unintentionally hit another car. So was careless at stopping at a stop sign, or while maneuvering the car, eventually was texting and driving and then lost attention. So uh, most, not in the online environment, but in our regular environment, most torts, they are negligent torts, because in most cases, we suffer losses or injuries based on unintentional or careless wrongdoing by others. Okay, another type of tort we call is strict liability. So this is when liability is imposed to a person or a company. However, this person or that company, they did not act with fault. So it is liability imposed without fault. The best example here is in an employment relationship. Um, during in the course of employment, if an employee uh, causes losses or injuries to someone else, the employer is liable for the employee's wrongful conduct as well. So what I'm saying is the employer itself did not act wrongfully. It was the employee themselves who acted um, either intentionally or in a negligent way. However, because of strict liability concepts, both the employer and the employee are liable um, to compensate the victim's losses. So, and why is the employer liable? It is because of strict liability. So, strict liability is when liability is imposed without fault. I will give more examples and more explanations for strict liability moving on. So now let's look at some specific torts, mostly related to online conduct, and they are invasion of privacy, intentional infliction of emotional distress, defamation, and defamation is present both in the online and also in the offline environment. Um, it does happen a lot in the online environment because people are posting, sending emails, etc. Uh, so that's also another tort that happens online. We have some economic torts, and then strict liability and products liability will be the last ones I'll be detailing to you. So the first one is invasion of privacy torts. So invasion of privacy is the main type, but is divided in sub types of um, torts. So there are three main um, invasion of privacy torts, and they are intrusion upon seclusion, misappropriation of a person's name or likeness. We also have the public disclosure of private facts and false light. So these are the torts related to invasion of privacy. And so the first one, intrusion upon seclusion. It is when there's an intentional intrusion into a private matter. And this intentional intrusion is by means of an objectionable um, way. So it's usually via an illegal means. So you do not have consent to intrude uh, someone else's affairs, and you do uh, enter such a space. So the example here is, let's say, an unauthorized access to a banking account. So let's say I work at a bank, and I know my neighbor has a banking account at the bank I work for, and I want to know how much my neighbor makes, or I want to know how much my neighbor spends. And without um, my neighbor's consent or authorization, because I have ways to access my neighbor's banking account. So I do look at my neighbor's banking account. So this will be if my neighbor happens to find out I did this, my neighbor can sue me for intrusion upon seclusion, and will mostly seek compensation for emotional distress, etc. Because I was looking at their own, my neighbor's private affairs. So this is the first invasion of privacy tort. A second one is misappropriation of a person's name or likeness. So when someone uses someone else's identity, could be a name or likeness, without their consent, and such use will result in an injury or in losses. And here the tort aims at protecting emotional interests. So I'm giving you here the example as the use of a celebrity's name or likeness to endorse a product. So that's an example here. But there's also, this is for a celebrity, for a famous person, but for a normal person, let's say myself, someone uses my name to post something online related to my profession as an instructor. So I could be a victim of misappropriation of my name or likeness. So here, this tort aims to redress or to address the issue of potential emotional interests or distress that will cause in the victim. And why I'm emphasizing this? Because we have the tort of we have the tort of right of publicity, and this is similar to misappropriation of a person's name or likeness. However, here the objective of the tort is to protect the commercial interests of a celebrity. So the best way to differentiate those two torts, the right of publicity and misappropriation of a person's name or likeness, they are similar in their requirements. However, here, the misappropriation can take place with a celebrity or not, because here the victim is actually affected on the use of their names, so their own feelings about it. Whereas in the right of publicity tort, here it's mostly related to a celebrity, because here the protection is towards the commercial interests of someone else's name. So we could also say that here, the example I'm giving you, the use of a celebrity's name to endorse a product fits better here as an example of a right of publicity tort. Okay, so they are similar in their elements, in their requirements. However, the protection here for right of publicity is of commercial nature, and here for misappropriation, the protection is on emotional nature. And then moving on, we have the public disclosure of public facts. So when there's, the name of the tort explains it. When this public disclosure of private facts is offensive and also objectionable to a reasonable person. So, for example, the victim has reviewed to their doctor a medical condition, and someone has access to the victim's medical records, and then reveals it in public. Let's say the person suffers from anxiety or any other mental disorder, or any other physical disorder that is not apparent, but the victim has revealed to their doctor under treatment, etc., has never made it public, but then someone else, the wrongdoer, the tortfeasor, finds it out and reveals in public. So that's the public disclosure of private facts tort. The false light. False light is very similar to defamation. So what is a false light? Is when a type of a view or an opinion is made public, but this opinion is actually is an attributed opinion, an attributed view, and this attributed view or opinion is not true. So let's say I am for X, the president named X, but someone publishes that I am for president named Y. But I am not for that president called Y. Then, if it is made public, I am actually a victim of a false light. So it's like defamation, because in a defamation tort, a false statement about someone else is published, is made public. And the difference here, it's important to, there's a light difference from defamation to false light, and this is the defamation actually aims at protecting the person, the victim's reputation, whereas in a false light, the tort aims at protecting a person's situation in which they will be offended or they will be embarrassed because others will have a view or a judgment about the victim based on what their attributed view or opinion was, their false attributed view or opinion that was published. Okay, so let's take the example of the American election now. So let's say someone is for Trump, but then there's a post, could be a tweet or any online post, saying that that person was for Biden. So here it is false light because people, let's say people who are pro-Trump will say, oh, I don't like this person because he is for Biden. It was just published that the victim is for Biden. But actually the victim now is embarrassed. The victim now is feeling offended because their opinion, their view was published in a wrong way, in a false way. So that's the false light tort. So the right of publicity we have discussed already, differentiating it from the misappropriation of a person's name or likeness. And then moving on, we look at intentional infliction of emotional distress. So the name of the tort is long, also abbreviated as IIED, which is when someone intentionally or recklessly causes someone else severe emotional distress. And this distress was caused because the defendant acted in an extreme or outrageous way. So let's say when someone posts derogatory or offensive comments about someone, could be in a website or an email. This could be defamation in some circumstances, but if the person is doing this frequently, the victim may start developing some mental disorders, and one of them, well, emotional distress. So it means that the victim has this intentional infliction of emotional distress tort to seek monetary compensation for their treatment, And there's also the remedy of injunction, we'll see later on, in a way that the court would make the tortfeasor, the wrongdoer, to stop posting such derogatory or offensive comments about the victim. This could also happen in an employment environment. So at a workplace, let's say a boss that is constantly shouting at their employees, using offensive words, derogatory comments during meetings. This intentional infliction of emotional distress can also take place in the offline environment, in a workplace, at a workplace, as I exemplified. This could also take place in an educational institution environment. So someone who suffers this from others in their classroom or others in the department or in the school. So that's and this tort, by the way, has become more and more relevant and present nowadays, because people have been suffering this a lot. Not only because of the external factors of life, etc., but also because the tortfeasors, the wrongdoers, have been pushing in an offensive way, have been um, speaking out offensive, derogatory words about others, and people feel emotionally distressed more commonly. This case, Delfino versus Giant Technology. So here, the court confirmed and held that there were that repeated threats of physical harm uh, um, in an email and also via the internet. They were sufficient acts of extreme and outrageous conduct, and those acts they supported a claim of intentional infliction of emotional distress. So, say victims of derogatory posts, even physical threats of physical harm. I'm gonna kill you. I'm gonna punch you. I'm gonna hit you whenever I meet you again, and you keep on posting this, etc. So this could constitute acts that would base an intentional infliction of emotional distress claim. I won't go into further details into proof, but just to add here, whenever a victim files such a claim, such a lawsuit, there's certainly a need to bring a doctor's um, report on their emotional distress. So it's not about our claiming, the victims claiming that they have suffered emotional distress, but I would argue that there's a need to bring evidence from a specialist, from a doctor, from a psychologist, from a counselor, psychiatrist, to base the claim on the top of the extreme and outrageous conduct of the defendant. Moving on, we look at cyberbullying and cyberstalking. So cyberbullying, it is when uh, electronic devices they are used uh, to bully people, others. So, like bullying, most people know bullying, and the cyberbullying is when bullying takes place via electronic devices. Examples here: email, instant messaging, texts, blogs, smartphones, etc. And cyberstalking is stalking, so someone is doing something but they are hiding, they act in a way not to reveal who they are. So they are stalking through the use of internet, email, and any other electronic communication. So the victim here is being followed by someone, but the identity of the follower, of the wrongdoer, is not known. So that's why it is called cyberstalking. Looking at some economic torts. So we have fraud and misrepresentation. So when there's a false when there's a false representation of a material fact, and this false representation causes the victim losses or injuries, then there is fraud and misrepresentation. So a simple example here, I have my laptop for sale on Craigslist, and I say it has an SSD, solid state drive of 256 gigabytes, but it also has only 128 gigabytes. So I am making a false representation of a material fact, and then the buyer only purchased my laptop because of the SSD, on the top of other characteristics or specifications, but still, my false representation was what led the buyer to purchase the laptop. So I committed a tort, and the purchaser was a victim of this fraud and misrepresentation tort, for example. There's also the tort of interference with contractual relations. So in this case here, the wrongdoer, the tortfeasor, they know someone is in a contract with a company or someone else, and they interfere in their contractual relationship. So let's say I have a contract with BCAT, and then another educational institution interferes in my contract and induces me to break my contract that will cause damage to BCAT. So this is an example of interference with contractual relations. And another one is the interference with prospective economic relations. So in this case, to a person and a company, they are negotiating an employment agreement, and then the wrongdoer, the tortfeasor, interferes, enters their relationship, and tries to get the job to themselves. So this is an example of an interference with prospective economic relations, or illegally getting customers through such interference. So those are examples here. Now we look at strict liability. So as I said before, strict liability is a liability without fault. So it is a liability that is not related to actual negligence or intent, regardless if the wrongdoer was negligent or not, intended or not. If they carry strict liability, as long as the harm took place, this person is liable. So the best way to memorize this is when we look at dangerous products. For example, atomic energy, explosives, flammable materials. So let's say explosives. So let's, in an example, I keep explosives in my garage. And even though they are properly packed, stored, there are warnings, etc., etc., but if they explode and cause damage to others, let's say neighbors or someone else, property, I am liable for those damages, because only for the fact that I was storing explosives. So regardless if I stored them properly or not, regardless if there were proper warnings or not, whoever stores explosives, they are strictly liable for any damages that take place if the explosives explode. Okay, so that's what strict liability is. Again, Um, the example I gave you before in an employment relationship. In the course of employment, any torts committed by the employees make the employer liable as well. So it is also understood as to be strict liability. So the employer carries strict liability. The victim can sue both the employee and the employer. The victim will only get paid compensation by one of them. And usually in those scenarios, the employer has a stronger financial situation than the employee. So the victim is better off suing the employer as well. But remember, uh, the person who acted wrongfully, committed a tort, was the employee themselves, not the employer. But anyway, the law says employers, they are strictly liable, vicarious liable, as they also call, uh, because the tort took place in the course of employment. Product liability is related to manufacturing defects or designing defects when there are issues with warnings or even inadequate instructions. So courts regard manufacturers or distributors, resellers, to be liable for issues with products. So you purchase a new laptop, and then the laptop seems to be working well when you are shown in the store. However, after you bring home and you start using it, working with it, you start facing manufacturing issues or even designing defects. Then you usually companies, they make it easy for us to replace a product with defects. However, if they don't, we have the tort of product liability available to sue either the seller, reseller, or the manufacturer. So now let's look at some remedies. Well, those are related to the victims. So victims of torts, any torts, the torts we discussed so far, what remedies do they have? So when they are suing the wrongdoer, the tortfeasor, what remedies will they be seeking in court? The main one is money, damages. So monetary compensation. In most cases, will be reimbursement for the monetary loss, the actual expenses. So if you had only material loss, so whatever you spent to recover or whatever you lost, if they were physical losses, injuries, then treatment, hospital, and everything. And on the top of those, you can also get compensation for pain and suffering, emotional distress, and humiliation in some cases. And so the main remedy, and also called the legal remedy, will be monetary compensation. There's also another remedy that is called injunction. It is known as an equitable remedy. So an injunction is what is it? It is a court order that commands or prevents an action by the defendant, by the wrongdoer. So when is an injunction available? It is mostly available when monetary compensation is insufficient or is not effective. And the example here would be, so let's say I am suffering the tort of defamation. So I want the wrongdoer, I want compensation, but on the top of that, or now before the trial, I want an interlocutory measure, provisional measure as an injunction so that the wrongdoer, the tortfeasor, stops issuing false statements about myself. Or you want, let's say, looking at intellectual property we discussed in this course. An injunction could also be, let's say, this reseller of fake goods. The owner of the brand, of the original goods, they want an injunction on the top of monetary compensation in a way that the court orders the fake goods reseller to stop reselling those fake goods. So that's what an injunction is, or an example of an injunction. There was this injunction issued in this Bosley versus wideweb.com, in which a reporter had their photo with a wet t-shirt displayed, not photo, video. So on the top of compensation the reporter was seeking, the court also ordered a preliminary, a provisional injunction, ordering the website to remove that video. So injunction orders are usually very effective. Not easy to obtain because this could cause some harm to the defendant, but if the victim proves that the monetary damages are insufficient, are not enough, and the chances are there will be irreparable injury, so the court will most likely grant such injunction as a remedy. Now we look at the types of defenses, so the last part. Now we turn into the defendant. So what does the defendant have available when being sued for any of those torts? So the first one is lack of jurisdiction. We discussed this in chapter 1 in more details. So let's say the victim lives in a state, the wrongdoer, the tortfeasor, lives in another state. So if the victim starts the lawsuit in their own state of residence, usually the defendant may be successful arguing that state's court lacks jurisdiction. Remember the concept of minimum contact requirement. So if the defendant does not have the minimum contacts in that state, that state's court has no jurisdiction. Another type of defense will be consent, and this is a full defense. Full defense meaning that if this defense is proved, then there was no tort at all. So let's say I am suing the tortfeasor, the wrongdoer, for defamation or for false light, for example, but then I had actually given consent for the defendant to publish what my view was, even my attributed view. So, and I, let's say, forgot about that, or it was in the past. So, what I'm trying to convey here is that if the defendant proves that the plaintiff, the victim, actually gave the defendant consent to act that way, then there was no tort. Another defense that is based on the Communications Decency Act is related to sections 230, 230 C, 1 and 2. It is called the Good Samaritan provision. And this defense provides immunity to online publishers. So let's say Yahoo, let's say YouTube, Vimeo, even Facebook, Twitter. They are just a platform. when a user publishes something, it does not mean that the publisher, the platform, holds the same views, the same opinions. So what sections 1 and 2 are saying is they are giving immunity for the publisher, for the platform, because it was not the publisher, it was not the online publisher actually publishing it. It was an individual user. So the user is liable for what they did, but not the platform, not um, YouTube, not Facebook. It was the single user or the group of users who published that. And another protection or defense here is that those platforms, those online publishers, they may remove content that are in principle objectionable, that are in principle not reasonable to the general public, and as long as they act in good faith, not in a biased way, so they may remove content. And if the user sues them because the user is seeking some compensation because they removed the user's posting or content, those online publishers or platforms, they will use section 230C2 in a way that they acted in good faith and the content that was removed is either false or offensive or derogatory to a reasonable person. So those are the two main defenses related to the Communications Decency Act. We also have sovereign immunity. This means that the government of the United States is immune. Their employees as well, their officers, they are immune in most cases for torts they may commit. It doesn't mean they have immunity for crimes. We're talking here about torts, so the private aspect of their acts and causing losses or injuries. There's also the defense of the First Amendment related to freedom of speech. And this principle is very, very strong in the US. So in most cases, not in most cases, sorry, but in cases in which, in some cases in which the comment may be derogatory or offensive, but still, if it falls within the freedom of speech because it's related to an opinion of someone, this defense may be successful. It has to be looked at on a case-by-case basis, but in most cases, the tortfeasors will try to use this defense. And the last one is the statute of limitations. So this is related to timing to start a lawsuit. So whoever is a victim of a tort has some time to sue the tortfeasor, the wrongdoer. And the general principle is 2 years. It may vary a bit. For example, in Canada, if you have a human right issue, you have up to 1 year to file a human right complaint. But in tort cases in the US, also here in Canada, the general rule is 2 years. So what this says is the victim has up to 2 years to file a lawsuit against the defendant, against the wrongdoer, the tortfeasor. And if it happens that the victim filed the lawsuit more than 2 years of the event of the tort, then the defendant will ask the judge to dismiss the case because of the statute of limitations, because 2 years have gone. So the plaintiff should be prevented from moving with their lawsuit. And you may find it to be unfair, but the rationale here is that the defendant cannot be under the threat of being sued forever, indefinitely. So the idea is that up to 2 years, the victim may decide not to sue because they cannot afford paying legal fees, or the victim may try to negotiate directly with the defendant a way to be compensated for their losses, etc. But if they are unsuccessful, within this 2-year time frame, they should start a lawsuit. If it's more than 2 years, then you cannot do anymore. So the wrongdoers, the tortfeasors, they cannot be under the uncertainty of being sued or not indefinitely. So that's the idea. Okay. So that's everything I wanted to share with you in this chapter 8, talking about tort law. So we discussed what tort law is. I differentiated a tort from a crime to you. We also looked at several types of torts, the several types of invasion of privacy torts, and also other torts of intentional infliction of emotional distress. We looked at the economic torts as well. The remedies available, which are mainly monetary compensation and an injunction. And we ended by discussing the defenses that the defendant, the wrongdoer, will have whenever sued for one of those torts. Thank you, and see you again in chapter 9. Bye now.